What first caught public attention was a photograph from the early 2000s, a single frozen moment showing Donald Trump, his future wife Melania, Jeffrey Epstein, and Ghislaine Maxwell together at Mar-a-Lago. A photograph that briefly appeared on a Justice Department website, vanished without explanation, and then quietly reappeared. But focusing on that image alone misses the far more consequential story unfolding behind the scenes. Because the real significance of the Epstein document release is not what has been revealed, but how aggressively parts of the political and legal establishment have moved to control what comes next, particularly as scrutiny turns toward individuals who were never charged, but whose proximity to Epstein is now documented. On January 30th, 2026, the Department of Justice announced what it described as the final release of material under the Epstein Files Transparency Act, a law passed with overwhelming bipartisan support, requiring disclosure of all unclassified federal records related to Epstein and his associates, and the numbers sounded staggering. More than 3 million pages of documents, thousands of videos, and hundreds of thousands of images. But buried beneath the headline was a critical admission. The department had identified more than 6 million responsive pages and released barely half, withholding the remainder under broad claims of privilege, privacy, and ongoing review. A position that immediately drew objections from lawmakers who pointed out that the statute does not grant the executive branch discretion to redefine full compliance. Within the released material, references to Melania Trump appear sporadically, not as allegations of criminal conduct, but as factual documentation of her presence in social settings connected to Epstein, photographs, guest lists, and event records that establish association rather than accusation. Yet the response from her legal team was swift and unusually aggressive, shifting the narrative from transparency to intimidation, as journalists, commentators, and authors who discussed those connections received legal threats demanding retractions and apologies under the threat of billion-dollar defamation claims, a figure so outsized that legal experts immediately recognized it as a deterrent tactic rather than a credible damages calculation. Several outlets and public figures complied, retracting coverage or issuing apologies, while others did not. Most notably author Michael Wolff, who had interviewed Epstein extensively before his death, and who publicly asserted that Epstein himself described facilitating the early stages of Donald Trump's relationship with Melania, statements that triggered immediate legal retaliation and ultimately prompted Wolff to take an unusual step by filing a preemptive anti-SLAPP action in New York State Court, seeking a declaratory judgment that his reporting and commentary constituted protected speech on a matter of extraordinary public interest. That filing fundamentally altered the legal terrain, because under New York law, it opened the door to discovery and subpoena power, meaning that a strategy intended to silence inquiry instead created a procedural pathway through which sworn testimony could be compelled, a development legal observers describe as a classic self-inflicted escalation. Complicating matters further, the First Lady's attorneys moved to shift the case into federal court, a maneuver widely interpreted as an attempt to slow proceedings, narrow discovery, and change procedural dynamics, while reports from process servers suggest repeated difficulty serving legal papers, raising additional questions about transparency and cooperation with lawful judicial process. All of this has unfolded against the backdrop of a Justice Department review process marked by inconsistency, missed deadlines, and redactions so uneven that the same names appear blacked out in some documents and visible in others. Errors that allowed outside analysts to reconstruct information the department intended to conceal, undermining claims that the redaction effort was purely technical rather than strategic. Critics also point to the role of senior Justice Department officials with prior ties to the president, noting that while no evidence has emerged of direct White House intervention, the appearance of conflict is unavoidable in a case where the executive branch controls disclosure of records that implicate individuals close to the executive itself. Polling conducted in late 2025 and early 2026 shows overwhelming public support for full transparency and growing skepticism that the government is acting in good faith. Sentiments echoed in congressional hearings, where members repeatedly asked why half of the identified records remain withheld months after the statutory deadline. The convergence of these factors, the partial release, the aggressive legal threats, the Procedural maneuvering and the resistance to oversight has led legal analysts to frame the current moment not as a scandal centered on any single individual, but as a stress test of institutional accountability, asking whether transparency laws have real force when they collide with entrenched power. The irony is that efforts to suppress discussion may ultimately prolong and intensify scrutiny, because every threat letter, delayed filing, and sealed document reinforces the perception that critical information remains hidden. And once litigation enters the discovery phase, control over the narrative often shifts from those seeking silence to the courts themselves. The Epstein case has always been about more than one man's crimes, exposing instead how wealth, access, and influence can distort justice at every stage, from charging decisions to plea agreements to posthumous accountability. And the current chapter continues that pattern by demonstrating how legal pressure can be used not to refute facts, but to discourage their examination. As the remaining documents remain sealed and court proceedings inch forward, the central question persists: whether the legal system will ultimately permit a full accounting of who knew what, when they knew it, and how consistently the rules were applied, or whether this episode will join a long list of moments where institutional caution eclipsed public interest, leaving transparency partial, accountability limited, and trust further eroded. Continuing seamlessly, same angle, same single paragraph style, no branding, no breaks. Here's the next section flowing directly forward, as if part of one uninterrupted report. The deeper implication of this moment is that the Epstein case has evolved from a closed criminal matter into a live constitutional question about separation of powers. Because Congress passed a law explicitly mandating disclosure, the executive branch acknowledged possession of the records, and yet unilaterally decided that partial compliance was sufficient, a posture that places enormous strain on the credibility of federal transparency statutes going forward. Legal scholars point out that if an administration can redefine all unclassified records to mean some records we deem appropriate, then future disclosure laws become symbolic rather than enforceable, and that concern is amplified by the fact that the withheld materials reportedly include investigative memos, co-conspirator analyses, and internal correspondence generated after Epstein's 2007 non-prosecution agreement, documents that would illuminate not just Epstein's conduct, but the decision-making of prosecutors, agents, and supervisors who allowed his network to operate with minimal interference for years. Members of the House Oversight Committee have privately indicated that they believe at least a portion of the unreleased files involve assessments of politically exposed individuals, whose inclusion would create significant legal and diplomatic complications. And while no names have been officially confirmed, the structure of the redactions themselves, entire sections removed rather than narrow privacy protections, suggests institutional risk management rather than victim-centered review. This context is essential when evaluating the First Lady's legal posture, because defamation law does not exist in a vacuum, and courts have repeatedly held that public figures connected to matters of profound public concern face a high burden when attempting to silence commentary, particularly when the underlying facts are drawn from government records, sworn testimony, or contemporaneous reporting. Anti-SLAPP statutes were designed specifically to counteract the chilling effect of outsized legal threats, and New York's law is among the strongest in the country, allowing defendants not only to dismiss meritless claims, but to recover legal fees and compel discovery into the motives behind the litigation itself, meaning that what began as an effort to shut down discussion may now expose internal communications, legal strategy, and decision-making processes that would otherwise remain private. Beyond the courtroom, the political consequences are already visible, as lawmakers who initially supported the Transparency Act now face pressure from constituents demanding enforcement mechanisms, including contempt proceedings, appropriations leverage, or independent review panels to audit the DOJ's compliance, options that carry their own risks, but reflect mounting frustration with executive discretion. International observers are also watching closely, particularly in jurisdictions where Epstein's activities intersected with foreign nationals and financial institutions, because the selective release of records complicates parallel inquiries and undermines claims of cooperative justice, reinforcing long-standing criticisms that the United States applies transparency standards unevenly when elite interests are involved. What makes this phase distinct from earlier moments in the Epstein saga is that the central tension is no longer about guilt or innocence, but about process, about whether legal systems designed to serve the public can function when those subject to scrutiny occupy positions of extraordinary power, and whether intimidation, delay, and procedural complexity can effectively substitute for factual rebuttal. As analysts continue combing through the released material, patterns are emerging that suggest the documents function less as isolated fragments and more as components of a broader evidentiary mosaic, one that traces relationships, access, and institutional response over decades. And while no single page delivers a definitive conclusion, the cumulative weight raises questions that cannot be resolved through silence alone. The next phase will likely unfold slowly, through motions, hearings, and incremental disclosures rather, than dramatic revelations. But its significance should not be underestimated, because each procedural ruling sets precedent not just for this case, but for how future transparency efforts are treated when they collide with entrenched power. The Epstein files, in that sense, have become a referendum on whether accountability mechanisms retain real force in modern governance, or whether they can be neutralized through delay, intimidation, and selective compliance, a question whose answer will reverberate far beyond any individual name contained in the documents. Picking up exactly where that thread leaves off and pushing the analysis forward in the same continuous, unbroken reporting voice. What is striking to legal observers is how familiar this pattern feels, because once an investigation begins to threaten reputational damage at the highest levels, the battleground almost always shifts from facts to procedure, from what happened to who is allowed to ask questions and under what conditions. And that shift is now unmistakable here, with every delay, jurisdictional fight, and sealed filing functioning as a form of damage control rather than substantive rebuttal. Former federal judges have noted that when powerful figures are confident the underlying narrative is false, they tend to welcome discovery as an opportunity to clear their names, whereas resistance to sworn testimony often signals fear of inconsistency, contradiction, or exposure of peripheral facts that complicate a carefully maintained public image. This is why the emphasis on venue matters so much, because state courts operating under robust anti-SLAPP frameworks are structurally less hospitable to intimidation tactics, while federal courts offer broader discretion on stays, removals, and procedural motions that can slow a case to a crawl, effectively exhausting an opposing party's resources before any factual record is developed. The attempted shift into federal jurisdiction therefore reads less like a confidence play and more like a time management strategy, buying months, if not years, during which public attention may drift, political alignments may change, and institutional pressure may dissipate. Meanwhile, the existence of unreleased investigative material creates an unusual asymmetry, where the government retains exclusive control over information that could either corroborate or contradict public reporting, yet declines to fully disclose, while simultaneously benefiting from the uncertainty that partial release creates, a dynamic that courts traditionally view with skepticism when transparency laws are explicit. Scholars specializing in constitutional accountability warn that this combination, selective disclosure by the state paired with aggressive private litigation by political actors, risks creating a de facto censorship regime without any formal suppression order, because the chilling effect emerges organically through fear, cost, and confusion, rather than overt bans. This concern is not theoretical, as newsroom editors have acknowledged off the record that Epstein-related reporting now triggers heightened legal review, insurance scrutiny, and executive hesitation, not because of evidentiary weakness, but because of the unpredictable exposure created by billion-dollar demand letters. The public, however, appears increasingly attuned to this dynamic, and polling trends suggest that attempts to suppress discussion often backfire by reinforcing perceptions of concealment, a phenomenon well documented in political science literature as the reactance effect, where efforts to restrict information increase its perceived importance. This feedback loop may help explain why attention has persisted despite the complexity of the underlying material, as audiences intuitively recognize that procedural maneuvering itself is a form of signal, indicating where institutional discomfort lies. Beyond domestic implications, legal analysts emphasize that unresolved questions surrounding Epstein's network continue to complicate extradition mutual legal assistance treaties, and cross-border asset recovery efforts, because foreign courts require clarity about the scope and status of U.S. investigations before cooperating fully, and ambiguity weakens those requests. In that sense, the cost of opacity is not merely reputational, but operational, limiting the ability of authorities to pursue justice for victims whose experiences span multiple jurisdictions. As the legal chessboard evolves, 1. Reality remains constant. Sworn testimony is the inflection point everyone appears to be maneuvering around, because once statements are locked into the record under penalty of perjury, narrative flexibility collapses, timelines harden, and discrepancies become legally consequential rather than rhetorically dismissible. Whether that moment arrives through civil discovery, congressional action, or future judicial orders is still uncertain, but the intensity of efforts to avoid it underscores its significance. This is no longer about a single photograph or a handful of documents, but about whether transparency laws and free speech protections can withstand coordinated pressure from those with the resources to test their limits, a test whose outcome will quietly shape how power is contested long after the headlines fade. Unclassified federal records related to Epstein and his associates, and the numbers sounded staggering. More than 3 million pages of documents, thousands of videos, and hundreds of thousands of images. But buried beneath the headline was a critical admission. The department had identified more than 6 million responsive pages and released barely half, withholding the remainder under broad claims of privilege, privacy, and ongoing review. A position that immediately drew objections from lawmakers who pointed out that the statute does not grant the executive branch discretion to redefine full compliance. Within the released material, references to Melania Trump appear sporadically, not as allegations of criminal conduct, but as factual documentation of her presence in social settings connected to Epstein, photographs, guest lists, and event records that establish association rather than accusation. Yet the response from her legal team was swift and unusually aggressive.